Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'm going to answer the question, what kind of estate or how large of an estate do you need to have to justify forming a trust? Do you need to have an estate value of $1 million, $5 million, or more? So there's many different types of trust, but in this video we'll discuss the most popular form of trust, the revocable living trust, that's designed to avoid the estate of the person who set up the trust from going through the court and attorney-involved probate. You see, if you keep your house, your real estate, your LLCs, your brokerage accounts, and other assets titled in your name, then when you die, the assets will be frozen and those assets cannot be transferred to your heirs until your heirs hire lawyers and go through what can be an expensive and burdensome court process, often referred to as probate. So many people create their revocable living trust. They transfer assets that they own that would otherwise have to go through probate into their trust. And when they die, the assets aren't frozen and third parties don't need court orders to get assets transferred to the heirs. The successor trustee that you name in your trust will have the ability to immediately transfer your trust assets to the beneficiaries you designated in your trust instrument. But sometimes people ask, how large of an estate should someone have before they create their living trust? Some people think there's an arbitrary estate value, and if your estate value is below that amount, then it doesn't make sense to create a living trust. And those same people think that if the estate value exceeds a certain threshold, then it does make sense to have a trust. Some people incorrectly base their need for a trust based on estate value, kind of like a potential retiree bases their ability to retire based on a threshold value of their investment portfolio. So one incorrect assumption is to gauge the need for a trust based on the estate tax exclusion amount. Probate and federal estate tax are two completely different things. Probate generally applies regardless of the size of the estate if you own assets that are in your name when you die and there's no other way to transfer those assets to your heirs without going through the court process. Federal estate tax applies, at least for people who die in the year 2023, if the value of the net estate, gross assets less applicable deductions, exceeds $12.92 million. And creating a revocable living trust and transferring assets to the trust does not remove the asset from your estate for federal estate tax purposes. So gauging the need for a living trust based on estate tax rules doesn't make a whole lot of sense. Although if someone dies with an estate these days that exceeds $12.92 million, they're likely to have many different kinds of assets, real estate, LLCs, shares of stock, brokerage accounts, and it's likely that transferring all those assets to a revocable living trust prior to death will make the estate settlement process simpler. In addition, some people don't realize that the federal estate tax planning that large estates do to take advantage of the unlimited marital deduction, which allows for married couples to use two estate tax exclusion amounts and have no estate tax payments due until after the surviving spouse dies, and the unlimited charitable deduction can be done through either your will or your living trust. Some people might say that if your assets are over or under some arbitrary figure, $500,000, $1 million, $2 million, then that's the best indicator of whether you should create a living trust. But there are estates out there that are worth less than some arbitrary number, but they have many probate assets. For example, they may own just a few shares of stock in many different publicly traded companies, and those shares are all directly held in different accounts at a transfer agent. Or someone might own many different LLCs, with each LLC having a bank account with a few $100s. Or they may own several pieces of low-value real estate in different states. But the fact that the person owned property in multiple states would require a probate in each state where they owned property. Estates like this, even though their total fair market value may be relatively low, may benefit from having them settled through a living trust as opposed to being settled through a court process and probate. On the other hand, there are some larger estates where a living trust may not be necessary because there are no assets or few assets that would be required to go through probate. So for example, if someone dies and all they own is a $3 million traditional IRA, a $1 million Roth IRA, both of which have beneficiaries designated on the financial institution's beneficiary designation form, a $1 million brokerage account with a TOD, transfer on death registration, and a $500,000 bank account with a POD, payable on death registration. Even though they have an estate worth $5.5 million, None of those assets will be required to go through probate because they all have beneficiary designations that would be honored by the various financial institutions. So the living trust to avoid probate is likely unnecessary, particularly if there is no need to leave those assets to a trust for a beneficiary due to beneficiaries being minors or financially immature. Or if we had a twist to this, if that same person who has all those financial accounts also owns a home, that person might say to themselves, you know what, I don't feel like creating a trust just to keep my home out of probate. I'll simply have a last will and testament, and then when I die, my heirs will get the bulk of my estate immediately through beneficiary designations. And if they have to wait a few months to deal with the home, so be it. And then there are a couple of groups of people who will say you don't need a living trust regardless of the value of the estate. One of these groups is the people who have been through a probate before and it was easy. You know, every probate doesn't have to be a nightmare. When someone dies and the survivors are really on the ball and the executor and the courthouse employees and the judges and the financial institutions are all on the ball and everyone's on their best behavior, it is possible to have a probate that heirs can look back on and say, you know, that wasn't that bad. After all, some states do have a probate system that's less expensive, less drawn out, and less intrusive than other states. But there's another group of people that also say you don't need a trust because probate's not that bad. And that group of people tends to be the probate lawyers. Yes, it's not uncommon for lawyers who make their living taking people and families through probate to declare that most estates should go through probate because, according to them, going through probate in the long run is easier than setting up and maintaining a trust. But be careful, because sometimes taking advice to put your estate through probate from people who financially benefit from your estate going through probate might be a bit biased. And then there's one group that tends to avoid setting up their revocable living trust. It's that person or that couple that feels they can't afford to set up a living trust-based plan. I'll give you an example. A couple in their early 70s may have a modest home and only maybe $100,000 of liquid assets, checking, savings, retirement accounts. That couple is genuinely worried that they're going to run out of money during their lifetime. They're saving every penny that they can in hopes that they're not forced to spend every bit of their liquidity. So I understand when someone or a couple chooses not to get a living trust because they're trying to save every penny they have for their living. You see, you're likely to incur a few $1,000s in legal expense, property transfers, and perhaps other costs when you set up your revocable living trust-based estate plan. And for that couple who may be fighting to survive financially, it's not uncommon to put the living trust plan on the back burner and keep fighting to just maintain some sort of savings. Sometimes you'll see that person or that couple set up a more economical will-based plan so that they have their power of attorney agents and executor of the will, and they name their heirs in their will, just in case when they pass away, they still have some assets to pass along. Legal expenses can vary from situation to situation, but a general rule is that the legal expense of setting up a will-based plan may be 1/2 or 1/3 the legal expense of setting up a living trust plan to avoid the back-end probate hassle and big expenses. So the bottom line on this question of how much of an estate do you need to justify forming a question comes down to most people who are at a point in their life and are serious about getting their estate legal affairs in order do wind up creating their living trust-based estate plan so that those trust assets avoid going through probate. My wild guess on my experience is that when you lump in all of the clients of our law firm, America's Estate Planning Lawyers, and the clients of many of my colleagues around the country, I'd say about 90% of estate planning lawyers' clients wind up setting up a living trust. But even though revocable living trusts are so commonplace, it doesn't make foregoing a living trust plan by setting up a will-based plan wrong. People with large estates, although this isn't always the case, people with large estates tend to have lots of different classes or types of assets, many investment accounts, real estate in different states, multiple LLCs or business interests, where requiring all that to go through probate is likely to be more of a burden than passing those assets along through a living trust. And finally, the will plan or trust plan decision is rarely the most important estate planning decision one makes when they're serious about getting their estate legal affairs in order. The more important aspects of estate planning include designating the right people to make your financial and healthcare decisions when you can't, putting the right distribution schedule in place for your loved ones, organizing and documenting your estate assets, arranging things to minimize or avoid estate tax, capital gains tax, or even income tax, and even perhaps having conversations with your future heirs, which can avoid conflict when you pass away. All those aspects of estate planning can be more critical to your plan's success than whether you have a will-based plan or a trust-based plan. So if you feel you need to get your estate legal affairs in order, you can, if you want to, click the link in the description below and request a no-expense Zoom estate planning design meeting with me, where we'll explore what you want to accomplish from an estate planning perspective and figure out the most efficient way to accomplish it through our national estate planning law firm, America's Estate Planning Lawyers. Now go ahead and have a great day.